You're getting close to retirement or you're a newly retiree individual and you've heard you have to get your estate planning done. You have to get those documents in place to make sure that if something were to happen to you, your estate is taken care of. You've probably heard that many times, but you don't quite understand what people are talking about or how to get started when it comes to preparing your estate plan as a pre-retiree or newly retired individual. Hi, my name is Derek Delaney. I'm a certified financial planner, and these are the type of conversations I have with my clients for a living. Let's talk about estate planning in more depth. The first thing I want to highlight is when it comes to estate planning, it's not you running out and creating the most complex type of trust you could possibly think of. Instead, the first place to start is to find some education about what is estate planning, what may or may not be applicable to your specific situation, and then find a professional estate planning attorney or platform you can go to for a consultation in order to implement anything specific you feel is appropriate given your financial situation. That is step number one. In addition to that, before you find that estate planning attorney or before you sign up on any sort of estate planning software online, you need to understand what options are out there and what true estate planning looks like for most people. Think of it as a three-legged stool for most people. In order to create a good estate plan, you need all three legs. Without any one of those, you go sit on that stool and you're going to fall over. Leg number one is a proper power of attorney document in place. A power of attorney document is a legal document that lets one person, which they call the principal, essentially you, give another person that they call an agent the authority to act on your behalf. And when we say the authority to act on your behalf, they can transact on your behalf. They can take care of your finances. They can do a bunch of other things for you when you give them that authority. It's important there are multiple ways to provide a power of attorney. The first one to highlight is a durable power of attorney versus a non-durable power of attorney. A durable power of attorney stays in effect even if you become incapacitated. If you provide somebody with a power of attorney on your behalf, you find that somebody is trustworthy enough to be your agent, and you're walking along the sidewalk in the middle of winter and you fall, hit your head, and go into a coma. Your power of attorney, if it's durable, remains for that agent. A non-durable power of attorney ceases to exist once you become incapacitated. So more often than not, most people like creating a durable power of attorney because they want that individual to exercise that power if indeed you do get to a point where you are incapacitated. That is where they see the most value. There's also something called a springing power of attorney, which springs into action if a specific event takes place, like if you become incapacitated, then that agent you have on record to take power actually becomes capable in doing so if that event takes place, which is why they call it a springing power of attorney. It only happens once that future event takes place, like incapacity. Power of attorney is that first leg of the stool. You have to find an agent, usually it's a spouse or a trusted relative or family member, that can step in and transact on your behalf, whether you are incapacitated or not. And if you want them to be able to transact on your behalf, especially if you are incapacitated, a durable power of attorney instead of a non-durable power of attorney could be beneficial. These are the type of conversations you specifically want to have with your trusted estate planning professional. The second leg of your stool is your healthcare directive. A healthcare directive is a document that you can have at home or on file with your primary care provider that says, if something were to happen to me and I can't make health decisions for myself, these are the type of decisions I want made for me on my behalf if I'm not healthy enough to speak for myself. If you are on your deathbed and there is a chance that the doctor could bring you back, but it's a very small probability and more than likely you're going to remain on a ventilator or in some sort of vegetative state, you are basically giving your medical provider or your family members the ability to step in and say, hey, we're going to end care. You can get better. Or maybe you're somebody who wants to stay in a vegetative state and you want the doctors and your family members to do everything possible to keep you alive. You put those wishes in your healthcare directive. When it comes time to make that decision and you can't speak up for yourself, your wishes are acted upon when it comes to your healthcare. Creating a healthcare directive is very important. You can fill that out, make copies, and your primary healthcare provider has one in your file. Maybe your children have one to understand your wishes. That is the second leg of the stool. The third leg of the stool is having some sort of will or trust document in place that dictates where your property is going to go after you die. There are a number of different ways you can transition property at your death to a beneficiary. The easy ways to place them as a joint owner of that property. If it's a specific type of account that you can place a beneficiary on, that's another way. For all other types of property, it may make sense to have a will created. If you have a complex situation where a trust could be beneficial, creating a trust will allow the facilitation of that property to whoever you want it to go to as easily, simply, and cheaply as possible. Do you choose a will? Do you choose a trust? Those are great conversations that you need to evaluate with your trusted estate planning representative, because whether a will or a trust is most important is completely dictated on your specific situation. There should not be rules of thumb that help you make that decision. But once you get that will or trust in place, along with that power of attorney and healthcare directive documents, you have the three legs of your estate planning stool in place that should give you a really good baseline from an estate planning standpoint that you can rely on moving forward. Is estate planning very important? Absolutely. Can it become very complex if your estate is big enough or you have enough complexity in your life? Yes. Step number one is to find somebody who can understand that and help guide you. Step number 2, 3, and 4 is to create those legs of your stool if it's beneficial given your financial situation. Those legs are a power of attorney document, healthcare directives, and having some sort of will or trust document in place. If you complete all of that, you are going to put yourself in a very good position from an estate planning standpoint where you can have a lot of confidence knowing that if something were to happen to you, your property and the people you love are going to be taken care of in the ways that you hope they would be, and your property is going to be facilitated in a way that meets your wishes if you aren't able to speak for yourself at that future date. Again, my name is Derek Delaney. I'm a certified financial planner. I run a flat fee wealth management firm, and these are the type of conversations I have with my clients. If you're interested in exploring what this type of conversation could look like or any other when it comes to your future retirement, I invite you to click the link below and schedule your free 20-minute consultation. Happy retirement planning.